It's Lawfare podcast. My name is Mykhailo Soldatenko, Lawfare legal fellow, and I'm joined today by Oona Hathaway, law professor at Yale Law School and president-elect of the American Society of International Law. Today we discuss the state of the norm against the use of force in light of recent events, and why that's troubling that there are some threats to the norm and what we can do about it. We discuss the policies of the current US administration, strikes on Iran, and the negotiations between Ukraine and Russia and their implications for the norm. Professor Hathaway, together with her colleague from Yale Law School, wrote a piece for Foreign Affairs saying that current events pose a threat to the world order based on the prohibition of the use of force. And their main argument is based on their 2017 book, The Internationalists, where they described how this new world order emerged. So, Professor Hathaway, could you please explain to our listeners who are not familiar with the Internationalists, what is this new world order? How did it emerge? How it's related to the Kellogg-Briand Pact and the UN Charter, and how it differs from the old world order where the war was bread and butter of foreign policy?
Yeah, thank you. And thanks for that question. So in the book, we start with what we call the old world order. And what we mean by that is sort of the way in which the world worked for hundreds of years, starting at least in the 1400s and up through at least the 1920s. And this is a world in which war was legal. War was the main way, in fact, in which states resolved their disputes with one another. It wasn't just a breakdown of law, it was a tool of law. And Hugo Grotius, who's known by many as the father of international law, actually wrote about war as a main way in which states would resolve disputes with one another, in which they could right wrongs, they could pursue their legal rights, is through going to war. And so we start there because I think this is a past, this is a history that many of us have kind of forgotten. We've lived, at least for the last 80 years, in a very different kind of world, one in which war is not legal and lawful, except in limited circumstances. And so what the book tries to do is kind of start readers off, realizing like the world we've been in is not the world that has always existed. And so part of the question is, of course, how did we get from there to here? And that transformation, we argue, got started through the 1928 Kellogg-Briand Pact, which, of course, if your listeners have heard of it, have thought of it as like the laughingstock of international law. It's sort of the butt of all the jokes. How could you possibly think that a treaty could do anything about war? What a joke. And what we try to say is that's the wrong way to understand the Kellogg-Briand Pact, that of course it didn't succeed at its goal of ending war. Obviously, World War II follows. But it set in motion this transformation in the legal order, and that you can't really understand the world we live in today if you don't understand that transformation. And the basic idea is that the Kellogg-Briand Pact outlaws war. It is, for the first time, the time which states renounce the right to resort to war as a tool of national policy. And that then requires changing the whole international legal system, which had up to that point been built on this idea that states can go to war and that's legal and lawful to go to war. And in fact, that's the way in which you right wrongs. And all of a sudden, now you're not allowed to go to war, and you have to kind of recreate the whole international legal system around a totally different foundational principle. And that then becomes the core of the UN Charter, which of course provides that states cannot use force against one another. And all of the rules that we have today around prohibition on conquest and prohibition of gunboat diplomacy and all the rest flow from this important transformation, this kind of critical transformative moment. And the last thing I'll say is just that the key argument here is that the foundational shift that takes place is around the legal treatment of war and whether war is lawful or not, and whether states can change legal rights through using military force or not. And the claim that underlies the project and this idea of the New World Order is that the modern international legal order rests on the prohibition of war, that is the kind of core foundational principle of the rest of the whole system.
I think an important question before considering why that's problematic, that it's unraveling, it's important to understand why it's important. So I think like for people who are in countries that are under armed attacks like Ukraine and other countries may have a different views than, let's say, people in Spain or people in the United States. There is an ocean between the US and Europe. There are no threats, like major threats of invasion in the hemisphere, neither from like Canada, Mexico, whatever. Why the ordinary people should care about this, that this order should be maintained?
Yeah, it's a good question. And the claim that we make, and I believe is true, is that this prohibition on force is the kind of foundational norm of the legal order, and everything else kind of is built on top of it. So if war is illegal, then conquest is illegal. If war is illegal, then gunboat diplomacy is illegal. If war is illegal, then the main way in which states can influence one another and engage in relations with one another is through trade and diplomacy and peaceful relations with one another. And so all the things that we've kind of come to expect from the global legal order really flow from this foundational principle. If you begin to weaken it, if you unravel that foundational principle, sure, the first ones to feel it are going to be Ukraine and then Poland and the Baltic states, maybe Canada. We're going to talk about that. But it's going to make for a radically more unstable world. It's going to make for a world in which no state can be entirely confident that its neighbor isn't going to invade it, that it's going to be immune from the use of force, that if it engages in trade relations with another state, that state's not going to turn around and just try and take back whatever you've just traded with them for. It just makes a much more chaotic and unstable world. And the United States, even though maybe at this moment it doesn't have reason to worry about other states invading it, I think that's fair to say. And I think Donald Trump certainly, part of his view here is like the U.S. has a big military, why not use it? But it does mean that we're constantly going to be in defense of our allies. There are going to be those that are trading partners who are at risk, that we're then going to be called on to try and come and defend. And it is going to, it's not just the U.S. that might use this force, it's our adversaries as well. And so we're going to be constantly kind of trying to press back at the margins with our adversaries through use of force. And use of force is not something that's just sort of an antiseptic thing. It's literally people's lives and destruction as opposed to engaging in trade and peaceful relations. So it will make for a much more chaotic and brutal world. And we won't be able to depend on the prosperity and peace that we have largely been able to enjoy, certainly for the last 80 years.
I think one of the main critique of the internationalists is directed at the fact that you give law so much importance. Yeah, and I think so. Harvard Kennedy School professor Stephen Walt wrote a review of the internationalists saying liberals saying no to wars doesn't mean ending them. So and kind of I think this argument goes that correlation does not mean causation. There are many factors. There are alliances, balance of power, nuclear deterrence, nationalism, free trade, you name it. They say you need to work with the balance of power structure and not concentrate so much on law. What's your reply to that? Why law is so important and the norm is important? And do you think that the primary reason that we have this, we had this more or less stable world, or there are other variables in this equation?
Yeah. So we wrote a response to Steve Walt's review, which I encourage listeners to look up, called "What Realists Don't Understand About Law." And it's on my SSRN page, and you can find it on Foreign Policy. And what I think Steve was missing there, and I think critics of international law generally are missing, is that all of those things matter. We don't deny that. Nuclear weapons matter, trade matters. These things all matter. They all make a difference. This is not an argument that power is irrelevant, but that power both creates law and then it reinforces and strengthens the law, and it acts in service of the law. And so, look, the United States was a key advocate of the modern legal order. The UN Charter, the first draft, was written in the US State Department in the midst of the war. And then the US, basically brought it to other countries and said, we think this is a set of rules that we ought to abide by. And of course, it was amended and negotiated and changed in various ways. But US believed in a system and advocated for a system and really fought for a system in World War II that prohibited war as a tool of resolving disputes. Now, did they do that in part? And did the US and UK and France support that in part because they had succeeded in doing a lot of conquest and they had a lot of interest in drawing the line at that point and saying, now is the time to stop, just as there are all these rising powers around the world? Sure, that was absolutely in their interests. It's also the case that the law then takes on a force of its own. They create it because it serves their interests, but it also serves all states' interests. Frankly, war is not in anybody's best interest. It's destructive and causes a lot of horror. And then, the U.S. after World War II was the only state that had nuclear weapons. If nuclear weapons were the only kind of story here, why didn't the U.S. use that to conquer all kinds of territory? Why didn't we take Greenland and Canada back then? Why stop at, what we took from Mexico in the 1800s? Why not keep going? Well, part of the reason was that we had this set of legal commitments and moral commitments, but the moral commitments were reflected in legal commitments around prohibition on conquest and prohibition on using force and threats of force to resolve disputes and to assert legal rights over territory. And so nuclear weapons, sure, they're in service of this goal and they support that goal, but it's not just nuclear weapons aren't the entire story, because if they were, we'd have wars between states that are not nuclear weapon states or not supported by nuclear weapon states, and we also don't see that. So it's also the case that trade too is enabled by a world where states can trust that the prosperity that they accumulate isn't just going to be taken from them. This is one of the kind of fundamental dilemmas of realist theory, is why would states ever trade with one another? Because whenever you trade with one another, both sides are advantaged, but one side is inevitably advantaged more than the other. It's impossible to have kind of perfectly even advantage gained from trade. And the realist theory goes, well, then, therefore, it's impossible to have any kind of real trade arrangement, because if you do, even though both sides are being advantaged, the fact that one is being advantaged more than the other means that the state that's the less advantaged one isn't going to want to enter into that arrangement, because the other side is getting more powerful than they are at a faster rate. They're accumulating more economic might, and therefore, the potential for military might. And so these arrangements are going to break down. And what we see in a world in which states actually are confident that there's a legal prohibition on wars that is going to succeed, they enter into long-standing trade deals and arrangements where, even though one side might be advantaged somewhat more than the other, they still nonetheless last because they don't have these fears. And then those trade relations help build broader and more sustained economic ties and communications and, broader understanding among communities and all these things that then further reinforce this idea that states are not going to go to war with one another. So it's not an either or, the two are working together, but the point that we're trying to make is that the law is playing this critical role in setting a set of expectations about how states can, what they can expect from one another, and therefore what their interests are in light of those expectations. And so it's not that law is acting contrary to interests, it's that you create law that serves your interests, and then it shapes your interests in ways that then are in service of the law. So that's, I think, the kind of complexity that political scientists, I was trained as political scientist as an undergraduate, I teach in the political science department at Yale. I think that's the piece that a lot of political scientists are missing.
Another I think so. You mentioned that the UK and the US, they played a significant role in building this order. And another prominent scholar of the past, who is a legal scholar, Carl Schmidt, he didn't read The Internationalist, but you mentioned him there.
He's one of the villains of our book.
He was of the villains of this notion. And he called this order Anglo-Saxon formalism, that this is just a cover-up for realpolitik. And I think the people who rely on Schmidt, they would make an argument that from the very beginning you had Yalta, you had spheres of influence, you had the Cold War, you had Reagan and Brezhnev doctrines, where everybody, like both powers, invaded countries based on the ideological reasons. One's to fight communists, another to protect socialism abroad. And so that was antithetical to this world order and to the UN Charter as such. So I think the question is that why do you pinpoint the collapse of the order right now? Is it plausible to say that actually there were problems with the norm from the very beginning, and it's up to us to make it strong in the future?
Yeah, I mean, I actually wouldn't argue with that. I do think that there have been failures from the very get-go. I mean, you know, I would add to that maybe the most significant failure is the Iraq War, which was, you know, in my view, pretty clearly a violation of the UN Charter. So there have been plenty of violations. And, you know, I think that it's important to recognize that the truth of that. But it's also the case that, look, law can't ever expect perfection or perfect compliance. And we wouldn't expect that of domestic law. We wouldn't say, well, because there are murders that still occur, therefore there's no point to having laws against murder. We'd say, no, you know, that's a breakdown in the system when murder doesn't happen. We should do everything that we can to prevent it. When we find somebody who is engaged in murder, we should prosecute them to the full extent of the law. And if they're found guilty, put them in jail. But we shouldn't sort of say, well, because there are murders, the whole system is kind of, there's no point to it all. And the way I think about it is that it's a constant project of trying to strengthen and improve the system and to try and do better, and to try and find the failures and find ways to respond to them and strengthen the system. And I think you see that over the course of the last 80 years. I mean, you see obviously the Cold War, the Security Council trying to find a way to work together, despite the fact that there's extraordinary animosity, particularly between the U.S. and the USSR. You see this in you know, the various illegal uses of force that have taken place, while still far more modest than the uses of force that took place before 1928 and 1945. You know, still not something to be ignored. And you see these constant efforts at trying to strengthen and improve the system. You see, for instance, new technologies of economic sanctions, you know, better mechanisms for what Scott and I call outcasting. So better tools for using the ability to respond through non-forceful means to illegal behavior, and to really strengthen the system in a variety of different ways, creating different kinds of coalitions. And so there's lots of ways in which there's this constant process of reinvention and creation. You know, the question is this moment all that different? And I guess, you know, that's a fair question. I think that the reason I worry that it might be, you know, and the question is, like, at what point, you know, does the system become so undermined that it just begins to fall apart? I think what to me at least feels different about this moment is that you have Russia on the one hand invading Ukraine in the most kind of flagrant violation of the UN Charter and first effort at conquesting Europe since World War II. You have China building bases on disputed rocks, islands, and reefs in the South China Sea. you have the United States now, which has been kind of the bulwark against both of those, has been since 2014 and the invasion of Crimea and the full-scale invasion of 2022 into Ukraine, like led the charge against trying to assist Ukraine in defending itself and sanctioning Russia for its illegal invasion and rallying the international community to respond and doing the same thing in the South China Sea, doing these freedom of navigation exercises and other things to respond to China's unlawful actions. Now, not only is the U.S. pulling back from those kinds of enforcement activities, those kinds of like norm reinforcing activities, which it's been doing for the last many years, but also sort of suggesting that maybe it's going to violate the rules too. And, talking about Canada as a 51st state and taking over Greenland and owning Gaza and invading the Panama Canal, like that's extremely corrosive. And it makes it seem that these rules don't really matter and that they're up for grabs. And by making what has been the unthinkable thinkable, it really, I think, might be the kind of the final blow. I hope it's not. I hope it's just another, chink in the armor and we keep going on. And to some degree, that depends a bit on how other states respond and whether they kind of step into the breach. But it does worry me that this might be the last straw, that this is the moment at which the dam breaks and the whole thing kind of falls apart.
And from your foreign affairs piece, I got an impression that your argument goes that you think the current U.S. administration has an intentional policy to dismantle the order, why other people may say that just they don't care about the key rules here, which would be a different scenario. And what do you think, is that like, and other people said that that's just a part of the unraveling of post-Cold War order, where the US had primacy, now it understood that it doesn't have that much power to defend the order, and that's why it somewhat softens its role of the world policeman, so to speak. So how it's like, is it this new world order and its crisis, if we can call it this way, and the international liberal order with the U.S. primacy, are they interrelated in that respect?
Yeah. So, I mean, this idea that, the U.S. is stepping back from its role as a policeman, if that was all that was happening, and that's when, we came into the Trump administration, I wrote an op-ed for the Times saying basically, we're about to find out how much American leadership mattered. We're about to see, this clearly Trump administration, Trump doesn't seem to care much about doing the work of policing the international legal order. And we're going to see whether that makes a difference. I think it probably is going to make a difference. We'll see. But I didn't at the time, I wrote it right after the election, didn't really anticipate that not only would the U.S. be pulling back from policing and enforcing the order, but that it might be acting in ways that violate these core norms. Now, it's important to note that a lot of this is so far bluster, right? There hasn't been a lot of action on it, although the illegal bombing campaign in Iran is some action. But some of the worst, claims of, making Canada the 51st state may just be kind of Trump being Trump. But I think what we tried to say in this piece is, look, if we're always just dismissing this as like Trump being Trump, kind of bluster, we miss the pattern. There is a real pattern that's developing here. And that pattern is one in which he seems prepared to, first of all, he doesn't care at all or doesn't seem to care at all about this central principle of the international order, that is a prohibition on use of force. He seems prepared to really use threats of force to strong-arm states into deals, part of his deal making. After the Panama threats, it didn't go unnoticed that Panama agreed to take in a bunch of these deported immigrants who weren't from Panama. The famous pictures of the immigrants in that giant hotel, none of them from Panama, but clearly that was a deal that was worked out with the Trump administration, and it seems likely that Panama did that in part to sort of make nice with the Trump administration and avoid any kind of military action. And that might be seen as kind of a soft gunboat diplomacy, which is, again, like really a erosion of a principle that states shouldn't be coerced through force into international agreements. And so I think it's just seeing, like, once you see this happening again and again and again, you see this pattern developing, which seems to be sort of testing the waters about this idea that maybe this is a dispensable principle. And there's a sense coming out of Washington right now that, look, we've got this nice big army, why don't we use it? And I think a lack of appreciation for the fact that, the US-led global legal order has been one that didn't depend on use of force and was, in fact, all about the rejection of that very idea. And a willingness to put that all at risk right now in a way that I think is different from anything we've seen up until now.
And so you mentioned the rhetoric in respect of Canada, Panama, Greenland. And so it's understandable why the threats of force are problematic, because they are prohibited under the UN Charter and so under the New World Order that you described. Do you think short of that, so statements, 51st, our cherished 51st state, Governor Trudeau, do you think those statements, which are likely below the threshold of the threat of force because there is no seriousness of it appearing soon, so do you think that's also corrosive in your judgment?
I do. I think it's very corrosive because it's walking that line, right? And it's suggesting that that's an acceptable thing to propose. It's obviously meant partially to needle. Again, this is where the question of how seriously does one take Trump and his threats, but it does feel a bit like an attempt at sort of messaging. To sort of test the waters of like how bad would it really be if we did this? What kind of reaction are we going to get? And it's being taken. I think what you can look at is how did people on the receiving end of these threats respond? Denmark it feels very threatened. Clearly, there was talk about sending NATO troops to Greenland. As a possible defense against a U.S. invasion, which of course is would be an oddity because it'd be NATO troops defending themselves against NATO troops. But people are taking it seriously in the countries where where these threats are happening. Canada is taking it very seriously. Canadians are incredibly upset. Ordinary Canadians won't buy U.S.-made goods. There's these vetoes of U.S.-made goods aren't traveling to the U.S. because they feel very threatened by this. In Panama, clearly they're quite scared because they've essentially pushed China's, well, it's not even China, it's got this Hong Kong-owned company that Hutchinson Ports that owns the ports on either side of the Panama Canal, has agreed to sell them to a U.S.-owned company, clearly strong-armed into doing that out of fear that Trump will make good on his threats. So I think we ought to take it from the people on the receiving ends of these threats as to whether they think they're for real, and they seem to think they're for real, and I trust them in that. And the fact that they're scared means that people believe that this could really happen, and that really corrodes the international order, because then when China does the same, or Russia does the same, or another state does the same, it's very hard to work up the same kind of pushback that was worked up against Russia when it invaded Ukraine, because maybe this is not really the underlying principle of the international legal order anymore.
So moving forward to actions, recent strikes on Iran, and in your New York Times op-ed, you said that they are unlawful. There are two arguments that some people put forward in support, and I think that let's start with the first one, the preventive collective self-defense of Israel, because Iran will have nukes and we want to prevent that. And it looks like the Bush doctrine, something that is, far from Caroline test, not that immediate. So why do you think that argument is not colorable?
Yeah, I mean, I think that the look, the UN Charter, Article 51 of the UN Charter, which provides for right of self-defense, provides for right of self-defense against an armed attack on a state. So the language of the charter specifically provides for an actual attack before you have a right of self-defense or collective self-defense. Now, then the question becomes, well, has there already been an attack? Can we include, all these various exchanges of fire between Iran and Israel as sort of part of a broader conflict? Or is it enough to say, well, it's imminent enough? There've been these threats, death to Israel, et cetera, that suggest that this is imminent. But there, I think it's very, so first of all, there hasn't been a kind of clear armed attack of the kind that relates to the nuclear threat. Obviously there hasn't been a use of nuclear weapons, thank goodness. And second of all, there's nothing that was brought out. There was no intelligence provided or even sort of statements made that suggest that something really important had shifted that justified acting now. Because at the moment that the strikes happened, they're in the midst of diplomacy and engaging in talks with Iran around, possibly creating a successor agreement to the Joint Comprehensive Plan of Action, which Trump in his first term undid, but which had been very successful in reducing Iranian enrichment of nuclear material. And so it's far from clear that the moment was ripe, that this was a moment at which this kind of a strike was necessary, that there was any kind of imminent threat. And in fact, Trump said in his, one of his many sort of statements about this, that, well, they've been threatening Israel for 40 years, or they've been sort of a threat for 40 years. And that suggests that there's not really anything particularly new or new intelligence that something was on the horizon that justifies an imminent strike. And there was never any attempt to go to the Security Council. There was never any attempt to bring in any allies. There was never really any attempt, either before or after, to explain it to the American people, to even go to Congress. So, it seems like it was done a bit on a whim. Or target of opportunity, I guess, but the normal rules of international law require more than that, and they just didn't show that there was enough of a reason that this had to happen right now.
So the Biden administration, so the U.S. government always consider it as a contingency that it may need to use force against Iran if Iran would go nuclear, and from the UN Charter perspective, that would be problematic in any case. If there was no threat of armed attack, just attacking a country because it developed a nuclear weapon, according to the traditional theory, would not be enough. So, and the fact that there was a threat of the US attack if Iran goes nuclear, Iran was arguably deterred. I'm not an expert in the Middle East, but that's what the conventional wisdom suggests. So, and my question is, do you think in such case, if we would imagine that diplomacy is exhausted and Iran goes nuclear and you have risks for the legal order and you have a policy question, whether you act or not, do you think so that's a question outside of the law, but what are your thoughts about that? Are there any situations where, other equities prevail?
Well, so one lesson I learned when I was a lawyer at the U.S. Department of Defense is don't answer hypotheticals. Because, clients always want to come up with hypotheticals and you get boxed into a corner when you do that. Look, I think there's a long way between where we are and that scenario, and a lot of possible ways to get off of that ramp. I think obviously there are critical diplomatic negotiations that were underway and that I hope will continue to be underway to try and address this diplomatically. I think that's the first and foremost critical tool. If you there are scenarios in which an administration might decide to violate international law, sure, but I don't think that would be that taking preemptive action is going to be consistent with international law. Presidents have decided to violate international law before. As a lawyer, that's not what I would advise, but that's, the job of the lawyer is to say this is what the law is and this is what the law isn't. And then it's up to the client to make the decision. I think that's what would happen in that situation. But it's hard to find a way of justifying that under international law. And here's what I will say is that once you start talking about preemptive self-defense and anticipatory self-defense and, all the Bush Doctrine language that was used to try and justify the war in Iraq, first of all, we can see what that leads to. The war in Iraq was, preemptive self-defense or anticipatory self-defense against believed weapons of mass destruction that turned out didn't actually exist. And that led to total catastrophe. And in many ways, we can trace a lot of the terrible events that have unfolded in the Middle East to that kind of original sin, in a sense. It gave rise to ISIS. It led to much, arguably played a significant role in the refugee crisis that we're still dealing with. There's a lot of ways that it really reshaped the Middle East for the worse. Not to mention the fact that the claims that were being made that there was going to be a mushroom cloud if we didn't act were clearly false because they never found any evidence that there was an active nuclear weapons program. So I think that just demonstrates the dangers of this kind of preemptive or anticipatory self-defense, is that it leads you to take actions that are not well justified. And then it creates justifications for others to do the same. Shouldn't be lost on us that Putin, when he invaded Ukraine, gave a big speech about the importance of self-defense and collective self-defense, and he's defending Russia and defending Russian citizens. He's echoing this exact same language. And so you're giving a justification to others to turn around and use that same language against you. And, I think that's the danger of taking liberties with law, is that you create the justification for others to do the same.
And could you please briefly, what's your opinion about another legal argument that I've heard on that? So I think that's the second main argument, is about that this is a continuation of Israeli armed conflict against Iran and its proxy Hezbollah, Houthis, and Hamas, and that's U.S. going into collective self-defense, protecting Israel in that conflict. What's the problem with that argument?
Yeah, look, there is a right of collective self-defense under the UN Charter, under Article 51. But in order to act in collective self-defense, the actor that you're acting on behalf of has to themselves have an Article 51 right of self-defense. And that means that, in fact, they have to be subject to an armed attack or an imminent, immediately imminent attack in the Caroline Standard way. And that that their response is necessary and proportionate to that threat. I think most international lawyers looking at this concluded that wasn't the case. And certainly there are a few lawyers who argued the other side. But I think it's far from clear that there was an imminent threat, and it's far from clear that this was necessary. And so without those basic requirements being met, then Israel wouldn't have had a right itself to act under Article 51, and therefore the U.S. doesn't have the right to act on its behalf under Article 51. So that's the kind of critical piece of this. And I just, from everything that I've seen, that those basic requirements just haven't been met.
And so an important factor in maintaining the norm is how the international community reacts. And so the NATO and Europeans' reaction to strikes on Iran was somewhat positive, no major pushback. German Chancellor Merz said that Israel is doing a dirty job for us. The word duty might mean not perfectly legal, but Mark Rutte said that he didn't see any violations of international law. And even Ukraine didn't call it either legal or illegal, called for diplomatic solution, but the main, spirit of the message was somewhat supportive. And so many people, and there are understandable reasons for that, because many European states don't want to have bad relations with the current US administration, and for Ukraine that's, in a way, existential to keep the support of the US government. And so many people then criticized the Europeans, saying that you support the order when it's in your interests, and when it's not, you just don't react. What do you think about that? Is that corrosive? Are you concerned about that?
Yeah, I think you summarize it well. Look, it's noticeable that unlike many other cases where the U.S. has used force in the Middle East, it did it entirely alone. So in the past, when the U.S. has used force in ways that, for instance, in Libya, it did it in coalition with NATO. When it used force in Kosovo, it did in coalition with NATO. When it used force in Iraq, it built a coalition, quote unquote, coalition of the willing. It is really striking that this was a kind of go at your own kind of operation. And it's not that the U.S. has generally acted collectively because it needed the military might of its allies, but that it understood that that was part of building a legitimacy and a sense of kind of buy-in from the international community with the actions. And they seem not to have made an effort to do that, but they certainly didn't get it, whether they made an effort or not. And so this suggests that the US really didn't have kind of deep buy-in from other partners. And I think that you're right, that many countries are just right now not looking to pick fights with the Trump administration. The Trump administration has made it clear that it's pretty vindictive and willing to go after anybody that disagrees with it. And kind of, I can imagine various leaders thinking, kind of, what's the point? This is said and done. It seems like they're not planning on kind of going back and doing this again. So, like, why pick a fight with the Trump administration now? But I think that failure to respond, and this is part of why this is so corrosive, is when you've got the United States, which has traditionally been the kind of actor that, well, imperfectly, but nonetheless still importantly, play the role in maintaining the system, is now acting in ways that are inconsistent with it. All those reflexes are to support the U.S. The reflexes are to think that the U.S. must have a good reason, even if when you look at the evidence, it seems like they really don't. And so, that's part of the reason I think this is so corrosive, because the player that you would be expecting would have some good legal justification for his actions seems not in the end actually to have had good legal justifications. If they have them, they certainly haven't shared them. And yeah, I think that's part of the reason that this is so damaging, is because it also leads others to fail to live up to their own principles. And look, the rest of the world has, throughout the war in Ukraine, been saying that exact same thing, which is now Europe really cares, and they're telling us that we need to join sanctions against Russia. They're telling us that we need to support Ukraine. But, they seem not to care about uses of force when they're taking place in the Middle East or in the global South. And so why should we be asked to make sacrifices to support this principle that seems to only really apply when it's Europeans that are on the receiving end? And I think this is just reinforcing that further, and the sense of alienation from the global system from many countries who I think otherwise really believe in these basic principles, understand that a prohibition on use of force is really in their best interests, but they just feel like the international system is kind of so hypocritical. And states that, when they're defending the international legal order are doing it in some circumstances and not in others. I think that does drain the system of a lot of the support that it otherwise would have.
And so, moving forward, in your piece, you also mentioned the negotiations of the so-called minerals deal, where the U.S. leveraged the aid in order to get some concessions from Ukraine. And the deal relates not only to minerals, it relates to infrastructure, profits from infrastructure projects, oil and gas production, and everything else. So, my question is, so it's a common thing in foreign policy to leverage aid, because that's just like one of power tools how you achieve your interests. And all US administrations did it in one way or another. Why do you, what do you think, what's the difference between legitimate and illegitimate leverage in terms of aid, and why you thought that in this particular context that was problematic?
Yeah, that's great. So, look, it's perfectly legitimate to use economic incentives to draw states into agreements. And, lots of agreements the United States enters into are done in that way, provides assistance, foreign aid assistance, other kinds of assistance in return for various agreements by foreign partners. Here, I think what the reason it feels different, even though you're right that it's about kind of provision of aid, so in a way you might say, well, it's just the same thing, is that the US is essentially threatening kind of to throw Russia to the wolves, or throw Ukraine to the wolves, to withdraw support, to stop supplying arms, which now, because the Ukrainian army has been getting arms and support and intelligence and all the rest from the US, really now they're set up around that infrastructure. Once you have a set of infrastructure of military goods from a particular country, you need to keep getting supplies from them. You need to be able to get ammunition to use your weapons. And if you can't buy that, you can't get access to it, you're incapable of defending yourself. So I think what's different here is that it's clear that the threat is not that the US is going to invade and take over Ukrainian territory, but the US is essentially going to let Russia do what it wishes and take Ukrainian territory without US support. And so while it's not a direct threat of conquest, a direct threat of use of force, it's sort of an indirect threat of use of force. And that, to me, is what really makes this different than ordinary run-of-the-mill promises of foreign aid and response in return for various kinds of international agreements.
And so right now there are negotiations between Ukraine and Russia. The administration supports them, promotes them in one way or another. There are changes in rhetoric recently. So, but the question that I have, so there is a continuing Russian aggression. And one may argue that a negotiated settlement on conditions favorable to Ukraine is a good thing. How to reconcile the norm against conquest and against the use of force with a peace deal with an aggressor? So would any agreement be null and void under the Vienna Convention of the Law of Treaties? Does it matter where there is a de jure or de facto recognition of the territories? And does it matter whether the Security Council steps in order to endorse the agreement? So and there is this dilemma between peace and justice, but I think there is the same dilemma between the world order and a negotiated settlement.
Yeah, it's a great question. And honestly, I am still puzzling over this myself. So the Vienna Convention on Law of Treaties provides that an agreement brought about as a result of duress, meaning a threat of use of force, is null and void. It is void. It's not that it could be voided or it could be like refused to be, that you could choose not to enforce it. It is void. And so given that, it is a real puzzle. How do you, in this case where it's clear that there's a threat of ongoing use of force, there is in fact an ongoing use of force, and that's the only reason that Ukraine would enter into an agreement? Because if Russia was to say, oh, we'll just go home regardless, Ukraine would never enter into the agreement. It suggests that it's very hard to imagine that you have an enforceable, binding international agreement in light of that. And yet, I think you're also right that it is in Ukraine's best interest to be able to negotiate a deal of some sort. It's up to Ukrainians to decide what that deal ought to be and what's acceptable and what's not. Um, but could it include concession of territory? That would be extraordinarily antithetical to the modern legal order. I mean, this would be a clear violation of the prohibition on use of force and conquest. And yeah, it's hard to imagine how that's enforceable or how that's consistent with the modern legal order. And yet, nonetheless, do we think Ukraine should be able to make that deal? I mean, certainly it feels to me that they shouldn't be compelled to continue to fight. Um, so, yeah, I'm not sure what the right answer is. I suspect what may end up happening is a non-binding agreement, because the truth is I'm not sure anybody believes that a binding agreement is going to be enforced anyway. So essentially be a deal, a kind of non-binding deal, not considered to be an enforceable international treaty, but a non-binding agreement where essentially I doubt Ukraine will concede the cession of the territory, but that they might have a kind of an agreed, ceasefire and, a line of demarcation,
Korea armistice.
a Korea armistice kind of situation. And I suspect that's the kind of thing that we're going to see. So it's not going to be a conquest exactly. It's not going to be recognized as Russian territory. It's going to be something similar to what happened with Crimea since 2014, where, most countries didn't recognize that as Russian. And yet Russia, has administered it as if it's Russia, and Russia claims it as Russia. I think you're going to see something similar to at least some parts of eastern Ukraine that are currently occupied by Russia. If there's a deal, I think that's what it's going to look like. And I think I suspect it'll be a non-binding deal, both because you have this legal problem and because truthfully, it's not clear to me it makes a difference. If it's binding or not, the fact that it's legally binding, what does that give you really in this instance? I mean, I'm a lawyer and I believe in law. I've also written a lot about the use of non-binding agreements. And in this case, I don't think that you get a lot from making it legally binding as opposed to having it non-binding. But that's just my guess as to where it's going to land and how one can square the circle of the Vienna Convention on Law treaties, which has this prohibition on duress precisely because of the Kellogg-Briand Pact. I mean, the author of the Vienna Convention on Law treaties specifically stated that whereas agreements that used to be compelled through force used to be perfectly legally enforceable because of the prohibition on war that was adopted in 1928, that was no longer true, and therefore agreements brought about in violation of this prohibition couldn't be enforceable. You know, this is going to be flaunting that basic principle, and therefore I think you can't have a binding treaty. But if it's a non-binding, it's not covered by the Vienna Convention on Law treaties, and you don't have that problem.
Oh, one problem that might happen with the non-binding agreements, because there is somewhat less expectation of performance, and when circumstances change, there is a risk that one party may say, circumstances changed, I want to renegotiate. And there was a similar problem with prior ceasefires. They were non-binding, and in a way, it's always, there is uncertainty with that. What do you think, if there is a non-binding agreement and it's endorsed by the Security Council, does it change an equation? Can the Security Council, would it be able to cure even the null and void nature of the binding agreement?
Well, I mean, so it's
Yeah,
not, yeah, it's an
tricky.
interesting question. That is a kind of arrangement that was done with the Joint Comprehensive Plan of Action. So the JCPOA with Iran was a non-binding deal. And then it was endorsed by the Security Council, and the Security Council backed it with a relaxation of of sanctions that had been mandated by the Security Council. So that was a kind of binding action in support of the JCPOA. So you could imagine that perhaps the Security Council would endorse a deal it can't turn a non-binding agreement into a binding agreement. But what it could do is it, could endorse it in the same way that the Security Council endorsed the JCPOA. So you could have a kind of combination. But the truth is, look, this problem about like it'll constantly be renegotiated, or Russia will backtrack on it, or Ukraine will backtrack on it. That's going to be true of a binding agreement too. Like that's just the fact of the matter. I think neither side really trusts the other. I think Ukraine has great reason not to trust Russia. And so I'm not sure. I'm not sure. I mean, look, somebody could come to me and say, well, here's the good reasons why you have to make it binding. And maybe there are reasons that I'm not appreciating. But on the face of it, it strikes me that you're going to have a set of deals. A lot of non-binding agreements do a lot of serious work that basically condition certain actions by one side on the actions by the other. And that is a kind of self-enforcing mechanism that's built into a non-binding agreement. So while it's not binding in the kind of formal legal sense, it's backed by certain kinds of promises. And then I imagine, and again, I don't know, I'm not involved in negotiations, but I imagine it will involve like positioning of NATO troops, or some troop, maybe if not NATO, some maybe US troops on the Ukrainian side, to try and provide some kind of guarantee that Russia won't come over the line. There will be various kinds of like facts on the ground that are going to be established to try and quote unquote enforce it, or to make it less likely that one side or the other is going to renege on it. And that's going to be meaningful, and probably just as meaningful as if it's quote unquote binding. I mean, there is a whole separate question. This is not our subject today, but there's a really fascinating question. It's like, what do you get from making something binding versus not? Written a whole article with Jack Goldsmith and Kurt Bradley called "The Rise of Non-Binding Agreements." About the increasing use of non-bindings and all the reasons that states are increasingly relying on non-bindings. And we say a little bit there about why, about this trade-off, but I think it's a fascinating ongoing question. And increasingly we're seeing states wanting to use non-bindings. And I think this is a perfect case where we're going to see, I would predict that's what we're going to see here.
So turning back to the crisis of the world order. So what the international community can do? What is the suggested plan of action? I think in foreign affairs piece, you suggested going through the General Assembly, where small and medium states would form coalition and do a pushback. Do you think that's realistic, especially how, some states tend not to push back against the US right now. Other states tolerate the Russian aggression against Ukraine. And it looks like it's moving forward, maybe not exactly, but to the sphere of influence in one way or another. So what is the way forward?
Yeah, look, I mean, I spent a lot of time worrying about this question. What can we do? And it's very easy to kind of throw up your hands and give up and think, well, that's been a good run. We had a nice 80 years there. Now, we're gonna descend into chaos and violence, and let's give up. I like to think that things are not all lost, that there are things that we could do to try and strengthen and reinforce the system and to try and hold it together as best we can. And when I think about how that could be done, I think that it does rest on not relying on the United States to play this central role in policing the legal order, because it's clear the US is not particularly interested in that job anymore. And I don't think that Europe by itself can just step into the void and replace the United States in this role. It both doesn't have the coherence and cohesiveness politically. It doesn't have the military and economic might to be able to do it. It's stretched thin as it is. It's an important player. It should play a significant role, but I don't think by itself it can do it alone. I think if the system is going to survive the current challenge, it's going to be because more states decide that it's important to step up, and that they shouldn't remain on the sidelines, and that they do need to do something to try and support the international system, and that they can't wait for the US to do that because it's no longer interested in that job. Now, are they going to do that? I don't know. It may not be realistic to hope for. Um, but if something good could come out of this moment of crisis, I actually think that is something good that would emerge, because we have had a system in the last 80 years that has been quite imbalanced. I mean, the P5 doesn't make a whole lot of sense in the modern global environment. These are the 5 states that kind of anointed themselves after World War II, but it leaves out a lot of the world. I mean, Africa, of course, is left out entirely. There are very powerful populous states, economically powerful states that are left out of the equation. And this would be an opportunity for states, I think, to come forward and say, look, we're not going to do it in the way that the US has done it, but we do think that these are principles that are important for us, that we believe in the prohibition on use of force, that states shouldn't be bullying one another into agreements, that we don't want to see a total breakdown into chaos, and that we're willing to work together with one another to try and enforce those legal rules, that none of us can do it by ourselves, but collectively we can make a real difference. And it may be too hopeful, it may be hoping for too much, but I think if there's a way out of this, that's the way out. And so, I do remain hopeful that other states will be willing to step into some of the breach.
And the final question that I have, so you mentioned potential chaos, and some people argued that actually the sphere of influence, the Concert of Europe style world global governance would be stable, because each great power would have a sphere of influence, they would balance each other, and there would be less wars. Why we should be concerned about that pathway to stability?
Well, I mean, first of all, the idea of spheres of influence really robs some of the weaker states within those spheres of any kind of ability to make judgments about their country's future for themselves. Because the idea is, of course, that the powerful states within the sphere get to dominate those within it. And that those within it kind of have to go along with what the powerful states want. So China gets to dominate its sphere, US gets to dominate the Western Hemisphere, Russia dominates Europe. And those on the periphery kind of hope that they don't draw the interest of any of the powerful states. That's a pretty unpleasant world to be in if you imagine that states want to be able to determine their own futures for themselves and not be bullied into making decisions based on what's best for the hegemon within their sphere. I think it's also the case that, look, there's lots of opportunities for conflict in that world. Those spheres are not necessarily well settled. Who's in charge of the South China Sea? I guess China would think that belongs to them, but is the U.S. prepared to concede that? Well, how about Europe? What about Western Europe? Is that the Russian sphere, or is that the American sphere? We have lots of historic and longstanding cultural, political, military connections in Western Europe. Does that fall into the Russian sphere? Are we prepared to give it up? So certainly the Europeans wouldn't want that, but they too don't want to be dominated by the U.S. either. So I don't think that's a particularly pleasing outcome for most of the world. It might be where we're headed, but I think we ought to do all we can to try and prevent that.
Professor Hathaway, thank you very much for joining Lawfare podcast.
Thank you so much for having me.